Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous the insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. And happy whatever day it is today. I think it's Tuesday. Happy Tuesday, my friends. Breaking news. I mean, we knew this was going to happen because there's supposed to be a Daubert hearing on Friday for Richard Green and or a argument of the motion that the prosecution made. That was, as you may recall, entitled Commonwealth's Motion to Exclude Defense Witness Richard Green's Debunked Opinions, in quotes. Maybe debunked should have been in quotes instead of opinions, but the defense is having none of it. None of it. They're like, yeah, no more shenanigans, no more tomfoolery, and absolutely no more ballyhoo. And how about no more chicanery either, because this is getting to be a little bit ridiculous. Oh, you're so welcome. Thank you guys for coming with me on vacation to Cancun to see Dave Matthews and Tim Reynolds, and for the 100 or so that were with me every night of the 3 that I live streamed a little bit of the show for you to watch with me. It was really awesome. It was really awesome because I know so many of you are Dave fans also, and I thought you might enjoy it. So I don't know what the hell's going on here. I thought I scheduled this for 1:45 and then I realized it was 1:30 and I'm like, oops. Because I wanted to, be the first one to cover this. So, sometimes you got to go when you got to go, even though someone else may be covering other things on Karen Reed right now that we've already covered. And, she's got like 10,000 people in her chat, so she doesn't need my people, right? Also, I heard that Judge Jeanine Pirro might be on the anti-Karen Reed side. Is that true? I haven't watched it yet. I'm going to watch it. Apparently, it's only on Fox Nation, and you have to subscribe to that. And so I did. I haven't even watched it yet. So there's that. I don't know what's up with Judge Jeanine. I apparently, from the people that I know, because I was in Mexico and I wasn't getting, American television so much, and I really, I wasn't really looking at it anyway, but it seems like Judge Jeanine, number one, doesn't know a lot about the case, perhaps, I think, and seems to think that Karen Reed is absolutely guilty, which I find kind of shocking because I usually do agree with Judge Jeanine. I usually do. So maybe she needs to call me. We need to have a little conversation so I can bring her up to speed on what's actually going on with the Karen Reed case, and maybe we'll see what happens with that. But I had already scheduled the show for tonight at 7 with Mark Betterow. So he's going to come back with me tonight at 7. There's a lot of other things we need to talk about. And then this opposition to the Richard Green motion dropped in the meantime. So I figure, let me come on and read this to you or with you. And then when Mark comes on at 7, save some questions for Mark. And we have other things to talk about too. Not just this. Like, we haven't even discussed, Mark and I, the Sallyport video debacle and the fact that none of that stuff was saved in its original form, allegedly, and that the defense expert went over to Canton PD and for a pre-arranged visit with Hank Brennan in the Commonwealth. And expert shows up and they're like, yeah, no, sorry, we don't have it. We don't have any of the original Sallyport video. We didn't preserve it. It's not on the system. Oops. Don't know. We don't know. Where is it? Shrugged. I don't know. Well, how'd you send it? Not really sure. Didn't even know what the expert was doing there. And that was crazy. We covered that last week. So you can go back and watch that if you haven't. Thank you, Justin Green, for coming in here with the early cash app. I appreciate you so very much. So this is in opposition to the prosecution's motion for a Daubert hearing on expert witness Richard Green. And remember, they attached something like a 40-page report of Ian Whiffen, but not an affidavit of Ian Whiffen, just the 40-page report, which we haven't seen because it wasn't, wasn't attached, or we didn't get it. It's just a report. It's not sworn to. It's not an affidavit. And, Cellebrite's great, or Cellebrite is not the gold standard. And here's something else that I'm watching today. Are any of you watching the Penny McGee trial that is in front of Judge Cannoni right now? This is really interesting because Penny McGee is a socialite, a Rhode Island socialite, had a fight with her ex-husband back in 2020. The trial's happening now. She elected, I think it was yesterday, to forego a jury, and she's having a bench trial in front of Judge Cannoni. I'm listening to it on Zoom because it's audio only. And then Court TV is playing portions of it, but it's like got commercials, and I don't even know if they're playing all the testimony, but it's interesting because here's the thing. Larry Tipton is the defense attorney. He's also the defense attorney that's going to be representing Brian Walsh. Judge Cannoni's demeanor with Mr. Tipton is a lot different than we've seen her demeanor with Alan Jackson. The whole prosecution, in my opinion, is completely politically motivated. How they have this woman on trial for manslaughter, I'll never know. Here's a very short snippet of what it's about. And you can tell me if you want to cover it because I like it and I'm going to cover it anyway, whether you want to watch it with me or not. Her name is Penny McGee, Penelope. In 2020, she had an argument with her ex-husband. He was trying to evict her from the home that I think she shared with her 3 children. Don't get me like all in the details right now, but here's what happened. The daughter was on the stand today. She goes over to confront him about this eviction notice that he's sending her. She has an argument with him. Maybe she pushed him. Maybe she didn't. Maybe she slapped him. Maybe she didn't. He had a prior stroke like 6 months before. In the middle of this altercation, he like falls down, and I don't even know if he died right then and there. He may have died like the next day because of his prior heart condition, not because of the altercation or the alleged assault. I don't even know if she actually touched him. I don't even know. She's on trial for manslaughter right now, facing up to 20 years in prison. Guess what her husband was? A Democrat. Guess who he worked for? He had I don't know if he headed up the presidential campaign of Dukakis all the way back in like whenever the hell that was, 1988. In my opinion, purely political prosecution of Penelope McGee. I can't even believe that this case is on trial because there's no evidence that there's any causation between the argument that she had with him and his death. It's mind-numbing. So if you guys want to cover that, let's cover it. Or I'm going to cover it anyway. Just be on alert. Make sure you have your notifications set and all that stuff so that we can watch it together. I think today's only day 1 of the trial. If I'm freezing for you, please just refresh your browser. I don't think it's me. So this woman who's a socialite is on trial. I think she's from Rhode Island originally. But this is so interesting because Mark Betterow has been saying for a very, very long time, sometimes bench trials are the way to go. And he's also said bench trials would be the way to go unless it's Judge Cannoni. So, I mean, especially in Karen Reed. So it's going to be very, very interesting to see what happens with this. I don't know does anybody know how many days it's supposed to go on for, this trial, how long it's supposed to be. I'm not even sure how long it's supposed to be, but guess who else is going to testify? Yuri Buchanan, because he was involved in taking the daughter's statement, and the daughter testified today to a whole bunch of stuff that she never told Yuri Buchanan. So it is very, very interesting, right? Jennifer Blair is the prosecutor. Thanks, Mastad. I just couldn't remember her name. And again, I watched it. They had the opening statements on Court TV. So I watched them. And again, Jennifer Blair, prosecutor. It's in that little tiny courtroom again that Judge Cannoni was in for the Karen Reed trial. Jennifer Blair stands up to do her opening right at her table with her back to the defendant and the defense attorney, and just gives her opening right there to the judge. It's mind-numbing to me that they can't get to the podium and properly give an opening the way it should be done. I don't care if it's a bench trial or jury trial. Get your butt up, go over to the ducking podium, and let's act professional. It's just wild. It's wild. All right. Crawford is all right. I don't know what you're talking about. All right. You guys are having a side conversation. I was waiting for some people to get here in case their late notifications were going out. So let us get on with our bad selves and look at the defense opposition to the Commonwealth's motion. This is docket number 460. We are up to 460. But this Penny McGee, that's her name, right? Penny McGee. It's wild. It is wild because we're getting to see how differently Judge Cannoni conducts herself in front of other lawyers, and especially in front of the bench for a bench trial. It's going to be crazy. I'm here for it. All right. Let us make that a little bit bigger. And this is a cold read for today. This is docket number 460. This just hit the docket at 11:05 p.m. It is now 1:47 on the East Coast. So you're getting it fresh and hot off the press. And here we go. And I've been saying this too, and I haven't read this yet, so I don't even know if this is what they're going to bring up. But you cannot use Daubert hearings as a discovery tool. Okay? This is not the prosecution's opportunity to get a couple of bites at the apple and basically take a deposition of an expert witness to lock them into testimony for fun. It costs the defendant money. It wastes judicial time. And the purpose of a Daubert hearing is supposed to be to determine whether or not the expert is qualified to testify at trial. Qualified. And the whole thing about the entire Dr. Marie Russell Daubert hearing, that was 2 days long, it was so outside the scope of whether or not she was qualified to testify as an expert that it was insane. It's like nothing I've ever seen before. A Daubert hearing is typically an hour, 2 hours, maybe, never 2 full days like that. That was just insane. It was way outside the scope. And now we see what the prosecution's trying to do. They're trying to get depositions of expert witnesses. Depositions are allowed in some criminal trials in some states. I haven't seen them in Massachusetts. So that's what it seems like. Yeah, exactly. A deposition. It's like, we want to use it as a discovery tool so that we can lock her into her testimony. And now it's kind of like, okay, just because an expert has a difference of opinion from your expert does not mean that you are entitled to a Daubert hearing. That is what trials are for. That is why we often call trials the battle of the experts, because my expert is obviously going to say something different than your expert is. And it is up to the trier of fact, which in Karen Reed's case, it's the jury. In the Penny McGee case, it's the judge because she waived a jury trial. It is up to the trier of fact to determine which expert they want to give more weight to, which expert they are going to believe. And in this case, it's Ian Whiffen versus Richard Green, and it's going to be up to the jury to decide who they believe. Okay, here we go. This is the defendant's opposition to the Commonwealth's motion to exclude certain testimony of defense witness Richard Green. Remember, this has to do with the 227 search allegedly made by Jennifer McCabe's phone of Haas Long to die in cold. Now comes the defendant, Karen Reed, Ms. Reed. I know you guys like to see this bigger, so let me make it as big as I can because I like a big font too, because I too need readers on top of my contacts, and I need to take off my glasses to read. Okay, so here we go. Now comes the defendant, Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of Richard Green as to his expert opinion that a Google search for how long to die in CIKD. Number one, his expert opinion that all right, wait a second. As to number one, his expert opinion that a Google search for how long TI die in CIKD or Haas long to die in cold was made on Jennifer McCabe's phone prior to 6:23 a.m. on January 29th of 2022. And two, his expert opinion that Jennifer McCabe's phone incurred user deletions of any data related to Google searches, and deny the Commonwealth's included request for an evidentiary hearing under the standards set forth in Daubert versus Merrill Dow Pharmaceuticals, Inc. And that is a U.S. Supreme Court case from 1993. And the companion case in Massachusetts is Commonwealth v. Lanigan from 1994. The Commonwealth has not made any showing that the qualifications or methodology of Mr. Green do not satisfy Daubert Lanigan. Instead, the Commonwealth's entire motion merely addresses the conclusions and opinions of Mr. Green, matters that courts resoundingly state are subjects for cross-examination and the jury, not the narrow function of the Daubert Lanigan judicial gatekeeper. We know how Judge Cannoni likes to remind everyone that she is the gatekeeper. Moreover, as this opposition clearly demonstrates, Mr. Green is eminently qualified and his methodology pertaining to the subject matter of the instant motion is reliable. Oh, un momento. As a result, in addition to denial of the motion, no evidentiary hearing is justifiable. Not only should you deny the motion to exclude his testimony, but we don't even need to have an evidentiary hearing. We don't need to have a Daubert hearing. He is completely qualified, and here's why. The motion of the Commonwealth to exclude the trial testimony of Richard Green is just the latest in the Gatling gun dystopian approach of the Commonwealth to deny Ms. Reed the ability to present her defense through her well-credentialed, methodologically reliable expert witnesses, so she can have a fair trial against the baseless charges lodged against her. Okay, good. I like it better when there's a little bit of snark in here. The Gatling gun dystopian approach. Welcome to The Handmaid's Tale. Norfolk edition. The expert witness of the defense here, Richard Green, testified as an expert witness in digital forensics in the first trial regarding his opinion that the Google search, Haas long to die in cold, existed in the data from the iPhone 11 of Jennifer McCabe with a timestamp of at or before 2:27:40 a.m. and in a deleted state, 2:27:40 a.m. search artifact, without any objection from the Commonwealth as to his qualifications or methodology. And for good reason. Mr. Green has been accepted in several United States courts as an expert in digital forensics. The methodology that Mr. Green employed in the first trial was the same methodology that the proffered experts for the Commonwealth employed. That is, Mr. Green and the two proffered experts of the Commonwealth received the same raw image file from Jennifer McCabe's iPhone 11, verified the hash signature value of the image file, took the image file and saved it to their computers, servers, hard drive, etc., and then processed and evaluated the image file with the appropriate tools, such as Cellebrite Analyzer and Magnetic Forensics Axiom. While Commonwealth witness Ian Whiffen used only the Celebrite physical analyzer and Ardex tools, which remember, Ardex is his own software that he developed. I think he has something like 60 worldwide users. It was 60 or 600, something like that. And in my opinion, his entire testimony was one long infomercial for his new software, Artex. While Commonwealth witness Ian Whiffen used only the Celebrite physical analyzer and Ardex tools, Commonwealth witness Jessica Hyde historically used 3 more tools than Ian Whiffen, and Richard Green used at least as many tools as Jessica Hyde, with Green and Hyde using 4 of the same tools. I think Green used 5, right? Notably, although Jessica Hyde previously used 4 of the 5 tools used by Richard Green in her initial analysis, all but Celebrite are now disconcertingly absent from her December 24. What? Hold on. Really? Okay. Let me start again. Notably, although Jessica Hyde previously used 4 of the 5 tools used by Richard Green in her initial analysis, all but Celebrite are now disconcertingly absent from her December 2024 report submitted with the Commonwealth's motion, despite her admonitions in her previous reports that it is best to use multiple tools. Yes, remember, I'm going to break from this for a second to say, remember when the Commonwealth had one of their most recent discovery exchanges? It was like Commonwealth's notice of discovery, number 53, 54, 55, 57, whatever we're up to. It's more than how many Super Bowls there have been. All of a sudden, in her new supplemental report, she's now not using anything except Celebrite. All but Celebrite are gone. But which is it? Is Celebrite accurate or it's not accurate? Shield and sword, shield and sword. The Commonwealth can't say Celebrite's accurate, but now, Celebrite's not accurate. It's not accurate in Brian Walsh's case when he searched up all those crazy things after he may or may not just have dismembered his wife and dumped her body in dumpsters all over the county and surrounding areas and town. His Google searches were not accurate. His Google searches are accurate, I mean, but Jennifer McCabe's are not. You can't, this county's going to have such a big problem. And this is hilarious because this is the first we're learning of this. We knew that she had submitted a supplemental report in December of 2024, but we didn't know that all of a sudden she decided to take out all of those other tools. And it says here, despite her admonitions in her previous reports that it is best to use multiple tools. Oh, Jessica Hyde, do not ruin your credibility over this case. It's not worth it. People have been retweeting her, and I think she's tweeted some stuff recently, and she does seminars and she teaches people how to, and she has said in several places that it is so important to use multiple tools. Importantly, it was undisputed by all expert witnesses at the first trial that the 22740 AM search artifact was indeed present on the iPhone of Jennifer McCabe after analyses using Celebrite physical analyzer forensic technology available and on the market at the time. It is thus completely inexplicable how the Commonwealth can now challenge the methodology of Richard Green, whose methodology is the same as and then more comprehensive than that of the digital forensic witnesses of the Commonwealth. It is the opinions and conclusions, not the methodology of the witnesses that differ. But that difference is not a Daubert-Lanigan issue. Ding, 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 ding. What has changed since the first trial? The answer is disturbingly Orwellian and brings the prosecution closer to, if not squarely within, the danger zone of legal tyranny. Oh, I love this. I love this writing. It is Orwellian, my friends. It's Orwellian. Big Brother is watching. After the first trial, the proffered expert witness for the Commonwealth, Ian Whiffen, a law enforcement-centric digital forensics consultant, appears to have gone back to his company, Celebrite, to have its researchers perform further updates to its physical analyzer programs such that the artifact containing the 2:27:40 a.m. timestamp has now suddenly disappeared from all Celebrite programs. What? 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 Oh, we're going to read Richard Green's affidavit after this, and that is what they cite here on page 6. Okay, let's digest that a little bit more. Ian Whiffen, after the first trial, appears to have gone back to his company, Celebrite. And when they say his company, they don't mean that he owns the company or that he created the company or that he's the CEO of the company. He works for the company. He's like a customer service rep at Celebrite. He went back to Celebrite to have his, quote, researchers, not his researchers, Celebrite's researchers, perform further updates, in quotes, to its physical analyzer program so that now the artifact containing the 2:27:40 a.m. timestamp has now suddenly disappeared from all Celebrite programs. Did he alter Celebrite? Let's see. We're going to see what Richard Green has to say about that. Thanks, Estrella. He's an employee, a project manager, but I think now I don't know. I thought he just was like the phone guy that would help you if you had tech questions. I'm not really sure. The 2:27:40 a.m. search artifact has now nefariously become, without explanation, the Orwellian, quote, unperson, end quote. And George Orwell has entered the chat. It's just gone. It just is. It just did. Celebrate has to know that Ian Whiffen is out there, sort of, bashing their software, right? He's still employed by them. I'm surprised. I don't think he's their spokesperson. He's not there on behalf of Celebrite. This is his side gig. Being an expert witness, right? Saying that their product doesn't work. Yeah. After Celebrite completely rid itself of the 2:27:40 a.m. search artifact that is incredibly inconvenient to the theory of the case of the Commonwealth now comes before the court saying the unilateral and unexplained Celebrite, quote, updates to, quote, remove the 2:27:40 a.m. search artifact should control whether a jury is able to evaluate whose digital forensics theory about the artifact is most accurate. Wow. Just wow. I think we are now past the twilight zone and we are into the Orwellian unperson zone. And in doing so, glaringly, the Commonwealth does not address the other forensic tools, such as magnet forensics axiom that Ms. Hyde used in 2023, that Mr. Green used in the first trial and continues to use up to this day, and that still contains and shows the 2:27:40 a.m. search artifact, nor the several other digital forensic tools that Mr. Green used. I mean, this would be funny if a woman's life wasn't on the line here, okay? Additionally, the motion of the Commonwealth is legally insufficient on its face. The motion is not supported by one affidavit. Slow clap for me. I've been saying that. I said it at the beginning of the stream. And you know I didn't read this yet because it's not redlined yet. It is facially insufficient. There's not one affidavit by a person with knowledge. The motion does not even begin to meet its going forward obligation to state how Mr. Green is now, suddenly after the first trial, supposedly not qualified. Nor does the motion even begin to identify what the Commonwealth believes is the proper methodology to address the 22740 AM search artifact, or why the methodology employed by Mr. Green to analyze it is not reliable. Perhaps this failure is due to the fact that Mr. Green is eminently qualified, including more qualified in data forensics than Mr. Whiffen, and that the methodology Mr. Green employed includes the same and entire methodology of the proffered witnesses for the Commonwealth, plus his addition of additionally accepted digital forensics tools. So, not just to break that down a little bit for you, not only did Richard Green use Celebrite, he used 4 other programs to analyze this data. Whiffen, apparently, is only using Celebrite and his own Artex. Jessica Hyde, in her brand new report, her supplemental report from December of 2024, is now disregarding all other software programs that she initially used and is now only using Celebrite. To prevent the continued abuses of Ms. Reed by the Commonwealth, including the bleeding of her financial resources and distractions from her and her defense team's preparation for trial, the invasion of the province of the jury, and other broader jurisprudential maladies, this court must deny the Commonwealth's motion and its included request for an evidentiary hearing. Start thinking of t-shirt ideas. Broader jurisprudential maladies. We've got the bleeding of her financial resources. And yes, this is actually, we've got 63 days until this trial is supposed to start, my friends, on April 1st, April Fool's Day, which is so fitting. We still don't have a decision from the SJC on the juror issue of whether or not it would be double jeopardy to try her again on counts 1 and 3, whether the court is going to have to call the jurors back in and question them about that. We still don't have that decision. There's 63 days left until trial. The Commonwealth is now trying to knock out all the experts who were deemed qualified by this exact same judge in trial number 1. And so having to stop what they're doing and now expend more resources, pay more money, fly the experts back in for this discovery tool that the Commonwealth seems to think is proper and usable in this situation, is ridiculous. We already read in the last motion for costs about the expert that flew in from Phoenix to go to Canton PD and was met by, I keep wanting to call her Colleen Hoover, Colleen Crawford, who's their new expert, who's been working for the Commonwealth and contributing to Michael Marcy's campaign on the side for a very, very long time. It was set up in advance with the DA's office. Expert shows up. Colleen Crawford has no idea what he's doing there or what he's looking for or why he would even think that that stuff still exists. It's mind-numbing. It is mind-numbing. Case history of the digital forensic analysis of the 22740 AM search artifact. For 3 years in this case, there has been no dispute over the methodology employed by the defense to address the issue of the 22740 AM search artifact. On June 21st, 2024, Richard Green testified at that trial as a defense expert without any objection as to his qualifications or methodology, the use of digital forensics tools to analyze data on the raw image file. As he stated in that testimony, after receiving the raw image file of the data contained on Jennifer McCabe's iPhone 11, Mr. Green used 5 digital forensics tools to evaluate and analyze the data on the image file. Celebrite Physical Analyzer, Magnet Axiom, Belkasoft X, Sanderson Forensics, Sequelite, Forensic Explorer, and Artex. He even, breaking from the document for a second, he even used Ian Whiffin's own homemade software program. See January 2025 Green Affidavit at 5-8. We're going to read that after this. Through the use of these 5 tools, Mr. Green found that the 22740 AM search artifact existed and appeared in a deleted state. It was there, and then she deleted it. Those findings were consistent with the April 24th, 2023 report of Trupala, what do I call him? Trooper Nicholas Garino, who testified as a proffered expert of the Commonwealth in the first trial. Mr. Garino reported that while the 22740 AM search artifact did not appear on the version of Celebrite Physical Analyzer he had used for his May 4th, 2022 analysis of Jennifer McCabe's iPhone data, Mr. Green had used the then newest version of Physical Analyzer, 7.61.0.12, which did depict the 22740 AM search artifact. Quote, the newest version was able to pull an artifact in the browser state.db wall file. Haas long to dying cold at 227:40 AM on January 29th, 2022, deleted. Inexplicably and unexplained up to this day, Trooper Garino did not disclose in his report of April of 2023 that the Axiom program he used at that time did show the 227:40 AM search artifact. Is this new information? I'll read that again. Inexplicably and unexplained up to this day, Trooper Garino did not disclose in his report of April 2023 that the Axiom program he used at that time did show the 227:40 AM search artifact. Carrie Bigstick, they should get an additional expert to counter Ian Whiffen. Why? Why do they need to expend more? Why do they need to spend more money? Green is the guy. Green is the guy who's going to counter Ian Whiffen. He's the guy, and he's a lot more qualified. And he's going to be a lot better prepared based on all of this ballyhoo that's going on right now. No shade to you, Chatter, who commented that. I just don't think that they need to. Or should have to. Mr. Green's findings were further consistent across all 5 tools that he employed. See January 2025 Green Affidavit, which we're going to read after this. And remain consistent with findings as of January 2025 from analyses performed in the most recent version of Axiom, which continues to report the 227:40 AM search artifact. Okay, so that's interesting. Axiom is still reporting the 227:40 AM search artifact, but the new version of Celebrite all of a sudden doesn't. Okay, every defendant out there, start banging on the jailhouse bars to get out, because Celebrite is not the gold standard apparently of law enforcement that everyone has thought it has been for however many years. People have been, defendants have been convicted on Celebrite data. It's a very slippery slope for Celebrite, if you ask me, in my opinion. Wow, just wow. Like Mr. Green, Mr. Whiffin's methodology was to use digital forensics tools to analyze the raw image file of data from Jennifer McCabe's iPhone. Unlike Mr. Green, however, Mr. Whiffin used only 2 digital forensics tools in his analysis of the data. Celebrite Physical Analyzer, his company's tool, and Ardex. And again, when they say his company, he doesn't own Celebrite. He did not create the software for Celebrite. Ardex is also his company, I believe. After performing an analysis using a then on the market Celebrite Physical Analyzer program, Mr. Whiffen testified at the first trial and reported that he had seen the 22740 AM search artifact. And this is quoting Whiffin's testimony. Looks like Whiffin's testimony transcript at line 1 through 10. So the 227, and this is quoting Whiffin's testimony, quote, so the 22740 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. And that is also quoting the Commonwealth's Motion Exhibit 1, which is the Whiffen report, the new 40-page report, depicting the 22740 AM search artifact. Thus, while he disagreed with Mr. Green's opinion about whether that information indicated a search for Haas Long to Die in Cold was conducted at 22740 AM, he did not dispute that this 22740 AM search artifact was present and in a deleted state during his analysis. Let's underline that. Oops. Because that is how important that is. All right, well, it doesn't want to. He did not dispute that this 22740 AM search artifact was present and in a deleted state during his analysis. Jennifer Hyde also employed this methodology, originally using Celebrite Physical Analyzer, Sanderson for Forensics Sequelite, Axiom Ardex, and iLeap. And this is according to her trial testimony. 4 of these tools were amongst the 5 used by Mr. Green in his analysis. In her May 2023 report and in her testimony at trial, Ms. Hyde agreed with Mr. Green and Mr. Whiffen that she had seen the 22740 AM search artifact during her analysis. Quoting her report from May of 2023. In the instance of the Google search, Haas Long to Die in Cold, that was recovered with the timestamp of 22740 AM was marked by Celebrite as having the timestamp and being deleted. She also admitted in her May 2023 report that the 22740 AM search artifact appeared in a deleted state. She disagreed with Mr. Green's opinion about whether this information indicated that a search for Haas Long to Die in Cold was conducted at 22740 AM. But she did not dispute that the 22740 AM search artifact was present during her analyses. Inexplicably, Ms. Hyde changed her analysis and findings from her May of 2023 report to align with Mr. Whiffen after a Celebrite manipulated update to one physical analyzer program. This is the new program, or this is the program to which they are referring, INSEYETS. I don't know how you pronounce that. INSEYETS, which the defense learned about approximately 1 week before trial began, magically removed the 22740 timestamp value from records sourced from the Safari's browser state.db. Magically. This is like, I remember the magical mystery Sally port. I remember making a thumbnail during the trial about the magical mystery Sally port. And now it's like the magical mystery new version of Celebrite that magically removed the 22740 timestamp value. Using only this, quote, updated Celebrite tool and no others, Ms. Hyde drafted a new report in December 2024, taking back, without explanation, her original conclusion that the artifact containing the 22740 AM timestamp was present on the iPhone of Jennifer McCabe in a deleted state. Okay, wow. So in her new report, she's just completely changing her opinion. I take it back. She admitting she was wrong, or she's just taking it back? Read that again. Using only this updated Celebrite tool and no others, Ms. Hyde drafted a new report in December 2024, taking back without explanation her original conclusion that the artifact containing the 22740 AM timestamp was present on the iPhone of Jennifer McCabe in a deleted state. Oops. She opined instead that the artifact containing the 22740 AM timestamp was not present in a deleted state or otherwise, citing merely an unsupported, conclusory, and scientifically insufficient assertion that the timestamp was, quote, not reliable. Compare the Commonwealth's Motion Exhibit 4, December 2024 Hyde Report, with defendant's opposition Exhibit 4 from May 2023 Hyde Report. Just changed her opinion. Like Mr. Whiffen, neither Ms. Hyde nor the Commonwealth explain how the update, in quotes, occurred or any scientific reasonings for the change. The Commonwealth simply makes the same bald conclusory statement as Ms. Hyde that, quote, further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown. Wow. Everybody's going to be getting out of jail now. Commonwealth motion at page 5. The Commonwealth provides no explanation for that assertion, nor does it provide any information as to the reasons why that supposed research allegedly finds the 22740 AM search artifact, and this artifact alone to be unreliable. It also provides no information about the methodology of that research or any other information regarding what changes were made, how, or why. Oh, Olivia, I don't know, Olivia, if you're here, but you're going to have a field day with this one. Critically, despite the manipulation associated with this unexplained update and the accompanying sudden change in the analysis of the Commonwealth's proffered experts, Ms. Hyde's second report, dated December 2024, does not represent a different methodology, but rather a narrowing of and change in opinion about the presence of the 22740 AM search artifact. In this second report, she employs the same methodology as she did in the first trial and as Mr. Green and Mr. Whiffen employed, but deletes mention of an inconvenient axiom tool she used in her May 2023 report, which as of the date of this opposition continues to show the artifact containing the 22740 AM timestamp in a deleted state to reach a different conclusion. The only difference, in fact, between the application of the methodology by the Commonwealth's proffered experts and the application of the methodology by Richard Green is that the former is entirely encompassed by the latter. That means that Richard Green did everything that they did plus, plus. Plus, plus. Mr. Green simply used more tools in employing the same methodology and thus was able to conduct a more thorough forensics data analysis. The appropriateness and reliability of Mr. Green's all-encompassing methodology is evidenced by the fact that all experts agreed and opined at some point during the first trial that the 22740 AM search artifact existed and appeared in a deleted state. Mr. Green's methodology is further supported by Jessica Hyde's testimony that, quote, it's important to use multiple tools so you can see the results from different data sets and be able to compare those results and enhance those with manual analysis. And that is coming from Jessica Hyde's trial testimony. And that doing so is, quote, absolutely pertinent and allows her to ensure that she's getting the most complete interpretations. She did say that during her testimony. I remember it. Do you? This mimics the approach of Mr. Green and is countered to the myopic and company-based approach of Mr. Whiffen, to which Ms. Hyde now disquietingly has morphed. Oh, Jessica Hyde changing her opinion. The experts' disagreement is not over the methodology, but rather their opinions on whether the 22740 AM search artifact indicates that Jennifer McCabe conducted a search for Hoslong to die in cold at or before 22740 AM. Contrary to the assertion of the Commonwealth motion at page 5, this is a paradigmatic battle of the experts. Argument. Let's go to the chat for a second. What's up? Thanks for your super sticker. Thanks, Angela, for becoming a new member. Glad to see you, Dean Jam. Glad you made it live. Thanks for being here for 11 months. K. Willis, the realtor, has gifted 5 memberships. Welcome. Welcome to the 5 new members. I think you're going to like it here. Hi, Laura. Thanks for the 5. Just like the playground when we were kids, the bully yells. I call that from now on, the rule is blank. It's not fair. Love you, Melanie. And chat. We love you too, Laura. Spanky does have some chutzpah with this, Laura also says. Yeah. Hi, Lady Zelda. Thanks for the 5. Did you see all the donations to Marcy campaign fund by the MSP and the Commonwealth expert, Colleen Crawford? Yeah, she's also employed by the Commonwealth. I looked up her salary too. I think she makes like, $130,000, $150,000 a year. Apparently, people who live in Massachusetts say that it is kind of par for the course that all of these underlings at the DA's office always donate to Michael Marcy's campaign. It's like an unwritten rule. Doesn't mean it's proper. Sebastian Anon says, are these idiots so determined to protect the McAlberts that they're going to compromise all of Celebrite? This is going to make it unreliable for all other cases that use it. Great point. Thank you, Sebastian, for the 10. Kay wants to know, thanks for the 10. How many hours does it take to put together one of these motions? It's not likely. It's not like they can have a template, as they will all seem very different. 100%. They will all seem very different. This one is 24 pages, hours and hours and hours of research, writing, getting a new report and an affidavit from Richard Green. I can't even estimate the number of hours that it took at what I'm sure is a very high hourly rate. And again, a lot of people think that the Commonwealth is just trying to bleed Karen Reed dry of money. Thanks, Wendy, darling, for your super sticker. Good to see you. And thank you, Sons107, for becoming a new member. Arlene, nice to see you. Moon Goddess, you're very, very welcome. That was a great time. It was fun having you guys there with me. Edward Scott says, Celebrate isn't worried in the least. The way our courts work, this kind of thing can never be used against the software or even these exact experts in any other case. Well, that's not exactly true. Their testimony can be used against them in other cases. The testimony of Whiffen could be used against him in other cases, and the testimony of Hyde could be used against her in other cases. But I don't know that they're not worried in the least. Do you work for Celebrate? I'm just curious. I would think they would not be very happy about this. That is just my own personal legal opinion that they would not be very happy about this at all. At all. Argument. The court should deny the Commonwealth's request to exclude Richard Green's testimony concerning the 2:27:40 a.m. search artifact. The motion of the Commonwealth is deficient on its face. Commonwealth's motion to exclude certain expert testimony of Richard Green is deficient on its face in the two aspects of the Daubert-Lanigan applicable to this motion. The Commonwealth claims that Mr. Green is not qualified and that his methodology is unreliable, but provides no explanation as to why. In fact, Commonwealth doesn't even describe the methodology of Mr. Green, which is it asserts is unreliable and seeks to exclude. We talked about that when we went over the Commonwealth's initial motion. That was all the way back, I think in the beginning of December. There was no affidavit of anyone with personal knowledge. They just attached Ian Whiffin's report. I don't even know if it was signed. It definitely wasn't under oath. It's just facially insufficient as a matter of law. And there was another motion, and I can't remember which one it was, where Eliza Little got up and argued the exact same argument to the judge. Your Honor, the motion is facially insufficient because there's no affidavit from a person with knowledge, and you must deny the motion. And she actually did. And we thought collectively, Mr. Brennan might have learned something from that, losing that other motion, or is this all just for show? And headlines. The Commonwealth's motion is not only bereft with respect to the two apt prongs of the Daubert-Lanigan inquiry, qualifications and reliability of methodology, but also with respect to other aspects of its analysis. Nowhere in the motion does the Commonwealth discuss the general acceptance precept of Commonwealth v. Davis or the 5 non-exclusive factors of Daubert. What little the Commonwealth does say about the law is rote and does not address the question at issue here. The Commonwealth also fails to mention that Commonwealth v. Rintala instructs that the crucial inquiry for Daubert-Lanigan purposes is whether the proffered expert is qualified. Mr. Green overwhelmingly satisfies the Daubert-Lanigan standard. I would agree. He has more experience, much longer CV, than Ian Whiffin or Jessica Hyde. And the motion of the Commonwealth is not supported by any affidavit. See Rule 13.2, which says, an affidavit detailing all facts relied upon in support of the motion and signed by a person with personal knowledge of the factual basis of the motion shall be attached to all pretrial motions. Shall. It's not optional. The Commonwealth additionally misses the point of a Daubert-Lanigan inquiry. It argues, for example, that Mr. Green's opinions as to the artifact containing the 2:27:40 a.m. timestamp, quote, lack any evidentiary support, end quote, quote, cannot be made in good faith, constitute, quote, baseless claims, and have been debunked. And remember, debunked was in the title of the motion, in the title. These claims, in addition to being false, have no relevance to the methodology inquiry. They relate only to cross-examination and jury determinations. Yes. Oh, yes. Oh, yes. B, even if the motion of the Commonwealth was not deficient on its face, Mr. Green easily meets the requirements of the Daubert-Lanigan. Broadly, the Daubert-Lanigan inquiry involves evaluation of both the qualifications and methodology of the proffered expert, citing Rintala. However, the crucial issue in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. In addition, under Daubert Lanigan. Quote, the judge acting as gatekeeper is responsible for making a preliminary assessment whether the theory or methodology underlying the proposed testimony is sufficiently reliable to reach the trier of fact. That is where she's the gatekeeper in deciding whether or not Richard Green is qualified to testify. In making that assessment, the court may consider whether the scientific theory or process, 1, has been generally accepted in the relevant scientific community, 2, has been or can be subject to testing, 3, has been subjected to peer review and publication, 4, has an unacceptably high known or potential rate of error, and 5, is governed by recognized standards. When applying this standard, judges must be careful not to invade the province of the jury. Critically, it is the qualifications and methodology of the expert, not their conclusions, which the judge is tasked with evaluating. Differences of opinion present issues of credibility, which are properly reserved for the jury. Citing Robiero, which states, once the expert's qualifications were established and assuming the expert's testimony met the standard of Commonwealth v. Lanigan, the issue of credibility was for a jury, not the judge. Accordingly, expert witness testimony should not be deemed unreliable simply because there's a disagreement of opinion or in the level of confidence among the experts, or because the judge disagrees with the expert's opinion or finds the testimony unpersuasive. Such disagreements make up the battle of the experts. Well, that's interesting because in the judge's written decision allowing Dr. Marie Russell to testify, she added a wholly unnecessary final paragraph in which she stated some of the ways that the Commonwealth might try and attack her opinion. Giving them a little bit of a hint about how, she might object, she might rule on some of those objections at the time of trial. Completely unnecessary. But I guess she just couldn't not say those things that she needed to say, because there was absolutely zero basis for disqualifying Dr. Marie Russell as an expert in the field of medicine and causation of the injuries to John O'Keefe's right arm. No reason. Number 1, Richard Green's education, training, experience, and familiarity with digital forensics qualify him as an expert on the topic. As to the crucial inquiry of the Daubert Lanigan standard, the proffered expert's qualifications, Rintala, Mr. Green clearly satisfies the requirements of the standard. Mr. Green has more than 25 years of experience as a computer forensics technician and more than 18 years of experience conducting electronic data analyses and investigations. Mr. Green has been accepted as a digital forensics expert approximately 24 times in the United States. 24 times. Do we think that he said something like 200 times or 2,000 times? I don't remember, but it was 24 times. Mr. Green was qualified and testified as an expert for the first time in 1996 after spending approximately a decade working in computer information technology and networking. Building a line of computers and doing computer repairs. In 2006, Mr. Green started a digital investigation firm called United States Forensics, which he still owns and operates today. His company handles between approximately 100 and 120 cases per year and receives annual inquiries for about 3 times as many cases. So that's interesting. He doesn't take every case that comes to him. His company has worked on civil and criminal cases across the country in both state and federal court and on behalf of both defense teams and law enforcement. So he's testified for both sides, civil and criminal trials. Hold on a second. Since starting United States Forensic nearly 2 decades ago, Mr. Green has worked full-time in digital forensics. In addition to being the company's president and founder, he performs the majority of the investigations. He specializes in computer, cell phone, cloud, audio, video, metadata, media, surveillance systems, and other similar systems. Mr. Green has significant education, training, and experience in the field of digital forensics. He holds an associate's degree in digital forensics and computer investigations. He's a certified computer examiner, CCE, with the International Association of Criminal Investigation Specialists, and he also holds computer-related crimes investigator, cybersecurity, and computer forensics first responder certifications. He's also a member of 4 professional associations in the field of digital forensics and was the keynote speaker on electronic data forensics at the National Association of Legal Investigators 2008 Midwinter Conference. Over the last 18 years of full-time work in digital forensics, Mr. Green has received daily on-the-job training. Namely, in addition to work he does every day at his company, he has participated in listservs, conducted research into the newest developments in digital forensics, and attended training seminars approximately once per week. I mean, talk about continuing ed. Once a week. Is listserv still a thing? Just curious. In total, he has participated in hundreds of training events offered by software companies who provide the digital forensics tools used by the experts in this case, including Celebrite, Magnet Forensics, and Belkasoft. Hundreds of training events. Mr. Green has attended 67 of these trainings, not inclusive of many of the web training sources that Mr. Green follows on a continual basis since 2022. So in the past 2 years, he's done 67 of these trainings. Oh, excellent. If anybody sends it to me, we can read it. Thank you, New Hampshire woman. Carino's first words spoken on the hot mic were "kill me." That is absolutely 100% true. Give me 1 second. While I check the docket. Looks like Mark and I are going to have plenty to talk about at 7 p.m. Don't even tell me mass courts is going to be down again. Do you mean Court TV got something right today? Well, I don't see it. I don't see it in the docket. This is, I mean, this is the opposition to the motion to dismiss on Richard Green, dismiss his testimony. But I do not see that the motion to dismiss for egregious prosecutorial misconduct or whatever they were calling it has dropped. So fake news. Hold on a second. Where's my paper? Okay, here it is. But where is it over here? All right, affidavit of Richard Green. That's 448. Where's that other one? disappear. Hold on a second. What number is this again? 460? Okay, there we go. Notably, Mr. Green has attended trainings hosted by Celebrite and Magnet Forensics every year for the last 3 consecutive years and by Belkasoft in both of the last 2 years. His affidavit accompanying this opposition affirms his broad and deep qualifications. They are broad and deep, my friends, broad and deep. Who drafted this, do you think? Alan Jackson? On December 31st, 2024, despite Mr. Green's robust digital forensic credentials and experience, the Commonwealth moved to exclude the proposed testimony of Mr. Green as the 2:27:40 a.m. search artifact. The Commonwealth's motion should be denied. The education, training, and experience described by Mr. Green is not only overwhelming in its own right, but also much more significant than that of the proffered prosecution expert Ian Whiffen. Right, I've been saying that too. According to his own trial testimony, Mr. Whiffen has testified in the United States only once in his entire career in Michigan. Once. Mr. Whiffen also admitted at trial that unlike Mr. Green, he has no specific certifications in digital forensics. No certifications. Other than a higher national certificate in computing, and does not have a degree in digital forensics or otherwise. He doesn't have a degree at all, apparently. By proffering Mr. Whiffen as an expert witness, the Commonwealth has tacitly affirmed its belief that Mr. Whiffen is qualified. Accordingly, the Commonwealth's arguments regarding Mr. Green's qualifications should be rejected. Like, hey, guess what? Our expert has 100 times the more experience than yours, and you think your guy's an expert, so therefore, your entire theory and motion is completely unreliable based on who you think an expert witness is. Contrary to the Commonwealth's contention in their motion, Mr. Green was not broad and vague during cross-examination. Commonwealth motion at page 3. In fact, Mr. Green answered clearly and completely the only question the Commonwealth asked him about his training experience and certifications. Out of the 5 digital forensics tools Mr. Green used to evaluate the data from the Jennifer McCabe iPhone 11, Attorney Lally chose one, Celebrite, and asked Mr. Green if he had a certification for that particular platform. Thanks, Jessica. Mr. Green stated clearly after seeking clarification of the question that he had no such certification. He added that his certifications are much broader as they concern digital forensics fundamentals, how to conduct investigations, and which tools to use. His answers were specific and appropriately detailed. The Commonwealth's statement is thus incorrect. Curiously, according to the Commonwealth's own argument by omission in this motion, Mr. Green remains qualified and his methodology is reliable in the several other areas of data forensics he testified about in the first trial. The Commonwealth challenges none of those several areas of digital forensics, namely the call logs deleted from Jennifer McCabe's phone, the screenshot of the contact for Uncle Brian A. deleted from Jennifer McCabe's phone, the location data from Jennifer McCabe's phone, the health data from Jennifer McCabe's phone, the location data from John O'Keefe's phone, and the health data from John O'Keefe's phone. That the Commonwealth does not challenge Mr. Green's qualifications as to these topics is further evidence of his eminent qualifications. Such a challenge would fail, as should this one. Right. So the only thing the Commonwealth is opposing is his testimony as to the 2:27 a.m. search. Everything else, they have no problem with his testimony. All of the things they just listed. Ridiculous. 2, Richard Green's methodology is reliable. Oh, thank you. Thank you. These are new Dave Matthews hearings from the show. Thanks. The Commonwealth's papers fail to identify a methodology for Mr. Green, let alone state why his methodology is flawed. And in fact, the Commonwealth cannot make such a statement because Mr. Green not only employed the same methodology as the Commonwealth's proffered experts, but expanded upon that methodology by utilizing more tools, performing additional low-level analyses, and examining overall user activity. The validity of Mr. Green's methodology is evidenced by the fact that all experts employed it and acknowledged at some point during the first trial that the artifact containing the 2:27:40 a.m. timestamp existed and appeared in a deleted state. Quote, so the 2:27:40 timestamp was correct insofar that the time is shown within the database. It was indeed a deleted record. Quote, in the instance of the Google search, Haas Long to Dying Cold, that was recovered with the timestamp of 2:27:40 a.m., was marked by Celebrite as having this timestamp and being deleted. Nonetheless, the Commonwealth now asserts that Mr. Green's methodology is somehow unreliable. It provides no competent evidence to support this contention. What little support it provides for its ipsy dixit assertions. Ipsy dixit, my favorite Latin term. Ipsy dixit, because I said so, because he said so. What little support it provides for its ipsy dixit assertions on issues for the jury and not a Daubert Lanigan inquiry misconstrues the evidence. Shocking. The Commonwealth claims that Mr. Green admitted that his misinterpretation of data caused Celebrite to update its physical analyzer program to remove the artifact containing the 2:27 a.m. timestamp. But a proper reading of Mr. Green's June 21st testimony transcript makes it clear that the question was poorly stated to the point of incomprehension. Yeah, I think we went back and watched that testimony, and the question from Lally was poorly stated to the point of incomprehension. In his answer, Mr. Green was making the point that as of June 21st, 2024, Celebrite had 2 contradictory versions of physical analyzer on the market. In one version, in Sayet's physical analyzer, the 2:27:40 a.m. search artifact had been removed, while another version, physical analyzer 7, still showed the artifact and in a deleted state. Well, that's interesting that they had 2 contradictory versions on the market at the same time. Beyond that, Mr. Green was simply stating his awareness that Celebrite made changes to its software sometime after his viewing of the 2:27:40 a.m. search artifact before trial on the only version of physical analyzer available to him at the time. This purported evidence of supposed unreliable methodology is not about methodology at all. It is about 2 Celebrite programs out on the market at the same time that are presenting differently about the 2:27 a.m. search artifact. That is a problem caused by Celebrite, not by Mr. Green. Moreover, the problem is for the jury to determine it is not a Daubert Lanigan methodology issue. It therefore does not support any basis for exclusion of any portion of Mr. Green's testimony under Daubert Lanigan. The Commonwealth also claims that Mr. Green's opinions lacked any evidentiary support, cannot be made in good faith, constitutes baseless claims, and have been debunked. First, contrary to the false and baseless assertions, Mr. Green's opinions are backed by significant scientific evidence. A NIST scientific, oh wait, hold on. And draw on the very same data contained in the raw image file obtained from Jennifer McCabe's iPhone 11, which all three experts relied upon. Second, even if these claims are accurate, the purported lack of evidentiary support the Commonwealth alleges would go to weight and credibility of Mr. Green's opinions, not the threshold question of whether his methodology is reliable. Hold on a second. Oh, you don't even know who Judge Janine is, Kim? Judge Janine Pirro. I don't know. She's been a talking head for a very long time. Didn't she once have a TV show too? Yeah, Rose, I don't know. I wonder if Celebrite's since put out another version. Interesting. Give me one sec. Likewise, what page are we on here? Likewise, the Commonwealth's claims that Mr. Whiffen performed a comprehensive study of the forensic data and that there's no evidence whatsoever on this device of a search conducted prior to 6:23 a.m. or of deletions. These claims are false. First, Mr. Whiffen did not perform a comprehensive study because he only looked at limited data, only used two tools, and relied nearly entirely on one, his company's tool. His analysis is certainly less comprehensive than that of Mr. Green, who used 5 tools. Second, there is evidence in the raw data from this device of the 2:27:40 a.m. search artifact and of deletions. This evidence was found in all 5 of the forensics tools used by Mr. Green. And the most up-to-date version of Axiom continues to show the 2:27:40 a.m. search artifact in a deleted state. Notably, Mr. Whiffen qualifies his statement to the contrary with, quote, of the data I examined. Third, Mr. Whiffen does not mention, let alone account for, the several anomalies of Mr. Green. No, I'm sorry, the several anomalies Mr. Green discusses in his affidavit accompanying this opposition that undercut the entire December 2024 report of Mr. Whiffen. Nor does Ms. Hyde. In any event, these claims by Mr. Whiffen are no more than reiterations of his opinions and thus clearly are not a Daubert-Lanigan matter, but are cross-examination and jury matters. That is what I've been saying all along, screaming into the closet. It's battle of the experts for a reason. The Commonwealth's claim that Ms. Hyde conducted an encompassing review is similarly false. In fact, most recently, Ms. Hyde did exactly the opposite. Contravening her own first trial testimony about the importance of using multiple tools, she produced a new report in December of 2024, relying only on the updated Celebrite physical analyzer. These phrases and claims used by the Commonwealth in its motion are not just incorrect. They further demonstrate a fundamental misunderstanding of Daubert-Lanigan's 2 core concerns: the province of the judge in a Daubert-Lanigan context and the province of cross-examination and the jury. These are not the only errors the Commonwealth makes in its motion. For instance, the first footnote of the Commonwealth's papers is incorrect. Celebrite is not the leading forensic data extraction software tool. Celebrite is a company, one of the companies that provides one of the digital forensics tools relevant in this case. It is clear that the Commonwealth's myopic focus on Celebrite Physical Analyzer is misleading and allows the prosecution to disappear the 2:27 a.m. search artifact. Love that. Just to disappear it. Despite Jessica Hyde's testimony during the first trial about the absolute pertinence and value of using multiple tools, the Commonwealth seeks to discredit Mr. Green, who did exactly that, while proffering experts who rely almost exclusively on Celebrite Physical Analyzer to perform their analyses. This contradiction sheds light on the undeniable effect of the Commonwealth's motion. Now discuss only one data forensic tool, Celebrite Physical Analyzer, manipulate all Celebrite Physical Analyzer programs through some black box process in the electronic back room of Celebrite, so they no longer show the artifact containing the 2:27:40 a.m. timestamp, and euphemistically label the mysterious and suspicious process an update in quotes. Whoa, there's so much in that sentence. Where do I even start? The electronic backroom of Celebrite using some black box process and euphemistically label the mysterious and suspicious process an update. That's beautiful legal writing right there. Then claim Mr. Green is unqualified and his methodology is unreliable simply because he will not play along with the manipulation of the Celebrite Physical Analyzer programs, especially in light of the Axiom program, previously used by Commonwealth witnesses Garino and Hyde, still showing the artifact containing the 2:27:40 a.m. timestamp and in a deleted state. In addition to the prosecution's newly contrived debunked narrative being false, the debunked, in quotes, parlance in a Daubert-Lanigan motion is inappropriate and can be seen as an improper attempt to garner media headlines and otherwise prejudice future jury pools. Wow. Yep. Yep. An improper attempt to garner media headlines based on the title of their last motion alone. Mr. Green's methodology is generally accepted in the relevant scientific community, such that this court need not reach the 5 non-exclusive Daubert-Lanigan factors. Tracy wants to know, does Hank not want to be a defense attorney anymore? Thanks, Tracy. I don't know. Your guess is as good as mine. Hit the like button. Thanks, Ohio Peach. And thank you, Joseph Keene, for gifting 5 memberships. Always such a kind and generous contributor to this channel. And AJ's Beard says that your daughter is accepted and is committing to the University of Colorado Boulder. Go Buffs! Go Buffs! That's amazing, AJ's Beard. Yay! Boulder is the best. Boulder forever. Proud alum, proud alum. That's amazing. Thank you. I'm so happy for you, AJ's Beard, and congratulations to your daughter. She's never going to come home. Thank you for Brenda for becoming a new member. And Sint Goddess, who chimes in here, the Commonwealth has practiced revisionist history in so many areas that it's just giving the defense more fodder for cross for every single witness and process. Yes, 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 it does. Okay. Revisionist history. Mr. Green's methodology was employed by the Commonwealth experts in this case, and it is supported by relevant digital forensics literature on best practices from the National Institute of Standards and Technology. As a result, Mr. Green's methodology is properly regarded as generally accepted in the relevant scientific community. Under Commonwealth v. Davis, this general acceptance by the relevant scientific community is sufficient. Therefore, pursuant to Davis, this court need not reach the 5 non-exclusive Daubert-Lanigan factors. The issue of the 22740 AM search artifact should reach the jury. This issue of the 22740 AM search artifact should reach the jury. B, even if this court reaches the 5 non-exclusive Daubert-Lanigan factors, Mr. Green satisfies them. Okay, so even judge, if you don't agree with what we just said, even if you want to move on to the next factors, he satisfies every single one and then some. Because general acceptance of Mr. Green's methodology by the relevant scientific community is sufficiently well established, this court need not reach the Daubert-Lanigan factors. However, even if the court reaches those 5 non-exclusive factors, Mr. Green's methodology satisfies Daubert-Lanigan precepts. Again, as to the first factor, Mr. Green's methodology is generally accepted in the relevant scientific, i.e., data forensics community, and indeed by the Commonwealth's proffered data forensics experts themselves. It's like, come on, man. Come on, man. Your own experts used all the same stuff that he used. And you're going to say that he's not qualified? And then magically, all of a sudden, magically, Jessica Hyde just completely disregards 4 of them. And now, inexplicably, is only using Celebrate. Yes, this is what they're going to be arguing on Friday. Thanks, Carly. They will be arguing this on Friday. Unless she's going to rule on this and just say, there's no hearing, Friday is canceled based on these papers, which is what should happen. But yet, here we are in the upside down world of Norfolk County. As to the second factor, the methodology and the tools used are regularly subject to testing, both by the experts who use them and the companies who provide them. This regular testing is made apparent by the many legitimate updates and improvements made to the tools by their respective companies, which result in the periodic release of new versions of these tools. Third, while the methods used in digital forensics investigations are often not peer-reviewed in a formal process, trustworthiness is established by members of the digital forensic community trying out proposed methods, testing, and circulating updates within the community. Because this testing of digital forensics tools takes the place of peer review in the digital forensics field, it is therefore sufficient for purposes of a Daubert-Lanigan analysis, which, quote, must be flexible, end quote, and which may require judges to apply differing evaluative criteria for different methodologies. Fourth, the methodology also does not have an unacceptably high known or potential error rate. The Commonwealth's own proffered experts endorse and employ this methodology as scientifically sound, reliable, and accurate. Finally, the methodology is governed by recognized standards. Nonetheless, all the proffered data forensics experts in this case are using the same methodology and in various instances at various times using the same or similar data forensics tools. In all events, the Daubert-Lanigan factors are non-exclusive, so no factor is dispositive. And they cite a case here, which stands for the premise that not all of the factors identified in Daubert will be applicable in every case. A trial judge accordingly has broad discretion to determine how to assess the reliability of expert testimony. Because Mr. Green is qualified and his methodology is reliable, the court must deny the Commonwealth's motion. Point Roman 2. The Commonwealth has not shown that an evidentiary hearing is required. Daubert-Lanigan evidentiary hearings are canceled in Massachusetts once papers in opposition to the request for such hearings are filed, demonstrating the lack of a need for the hearings. See Commonwealth v. Atty, affirming judge's decision made on the basis of the parties' papers and arguments not to hold an evidentiary hearing and to admit the expert's testimony. See also Palandangian. This is another case that fits under this proposition. The core concern of the Daubert-Lanigan standard is promoting reliability by ensuring an expert has sufficient qualifications and employs a reliable methodology. See Rentala. This opposition establishes Mr. Green's eminent qualifications on the subject matter in dispute and the reliability of his methodology. The Commonwealth's bare and conclusory assertions to the contrary are insufficient to warrant an evidentiary hearing on the issue of the artifact containing the 2:27:40 a.m. timestamp. And I agree. Not only is it facially insufficient because it does not attach an affidavit of someone with actual knowledge, but for all of the reasons that they've set forth, including the methodology used by Green is the exact same methodology used by the Commonwealth's experts. It's like, I know you are, but what am I? The Commonwealth's motion appears to stem not from a genuine dispute over Mr. Green's qualifications and methodology, but from its transparent and disquieting campaign to deny Ms. Reed the ability to present her own defense through her own qualified and reliable witnesses, to prevent the ultimate jury from receiving and evaluating evidence that is harmful to and inconsistent with the Commonwealth's theory of the case, and to drain Ms. Reed of her resources in advance of trial in the process. By submitting conclusory and insufficient motions under the guise of Daubert-Lanigan, the Commonwealth seeks to force the defense to repeatedly participate in unnecessary motions and attendant resource-intensive mini-trials, thereby needlessly expending limited defense resources and diverting them from trial preparation. Through this misuse of Daubert-Lanigan, the Commonwealth is also effectively obtaining depositions of defense expert witnesses. I said that too. I swear I didn't read this first. Including the attempted locking in under oath of their testimony for use at trial. This instant motion and others like it are tantamount to legal tyranny, not a search for truth and justice. I have t-shirt ideas swirling in my head right now. Allowing the Commonwealth's motion to exclude Mr. Green would not only sanction this misguided and disturbing approach, but also the impermissible and intolerable adverse jurisprudential consequences of the Commonwealth's actions, which would extend beyond the instant case. Allowing the Commonwealth's motion would set a precedent that when the Commonwealth does not like a proffered expert's opinion, it may file rote, vague, legally insufficient, and vexatious Daubert-Lanigan motions to exclude that proffered expert and, most important, the evidence associated with the expert. That is, the Commonwealth will make Orwellian unpersons of the evidence, which is problematic for its theory. The danger of this approach by the Commonwealth and the precedent it would set cannot be overstated and respectfully should not be countenanced by this court. For these reasons, the Commonwealth's motion, along with its included request for an evidentiary hearing, must be denied. Must be denied. XOXO. Oh, wait. Conclusion. For the above reasons, Ms. Reed respectfully requests this honorable court deny the Commonwealth's motion to exclude certain testimony of defense witness Richard Green and its included request for an evidentiary hearing. XOXO. Robert Alessi coming in hot. Coming in hot. Ding, 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 ding. And of course, David Unetti, Ian Hengy, Alan Jackson, Elizabeth Little. But since Mr. Alessi was the first signature line, I'm imagining he drafted this and he will be the one to argue this on Friday. Love getting a New York attorney in here. So great. He's the one who sent it out. He served it from his New York office, and therefore, it's my guess. Let's go to the chat for a second. What say you? Thank you on top for another super sticker. Pro Gamer has been hanging around for 9 months. Woo woo. This case is incredibly disturbing for me. Thank you for covering it. My grandkids changed my YouTube name and I can't get it back. Thank you, Sue. Now you're a pro gamer. Your grandchildren changed your username. Custom Shadow. I highlighted this to come back to it. It's surprising that Celebrite Corp allows one of their employees to create a competing analyzer software. Most companies would consider that a conflict. Maybe a violation of their NDA and employment agreement. I don't know. I'm sure they have a non-compete, right? Yeah, that's very bizarre to me as well. So I'm very curious about whether he still works there, but apparently he does still work there. So the whole thing is curious and curiouser. That's right, Dennis Tank. Let's duck and go. Let's duck and go. No, they did not ever submit a motion to exclude ARCA yet. No, they did not. And you know what's also interesting here is that we know there's a hearing on Friday, but when I look in mass courts, hold on. I don't know if they've got it in there. Oh, it's in here now. All right, it says motion hearing. So there is a motion hearing scheduled for the 31st, which is Friday. But remember she said to hold those 2 days in February in case they needed them for Daubert hearings on ARCA, but that's not in here either. So we know that 9 a.m. Friday the 31st, there's going to be a motion hearing, and it is going to be this motion. That is my understanding. If anyone has any different information, certainly let me know. Let's look at Richard Green's affidavit. It's 13 pages, but a lot of it is his CV. So let's take a look at that before I have to run off and do my mother Uber driving, my mommy Uber this afternoon. Oh, thanks, Karina. Thanks for Karina. First of all, for being with me for 11 months as a member, and also for saying I know it's a good day when Melanie is streaming. We're coming back at 7. Don't forget. When I end this, it's going to teleport you to the 7 p.m. stream when Mark Betterow is going to be joining me, because Mark and I have not done a stream together in a very long time. And there's so many things that I know you want us to talk about, not just this, so many other things. Thank you, Mama She, for the 20. Great to have you back. And thank you so much for sharing Dave Matthews with us. You the best. No, you are. No, you are, Mama She. No, you are. No, you are. Okay, here is the way it's done, my friends. Here's the way it's done. And Robert Alessi knows the way it's done, because this is the way we do things in New York, Ms. Reed. And this is the way you're supposed to do things in Massachusetts also, Mr. Brennan. But apparently you didn't attach an affidavit to your motion, so therefore it should be automatically just dismissed outright from jump. Here's the affidavit attached to this motion that was drafted, as we know, by our friend. Well, he's not really our friend, but he's our virtual friend, Robert Alessi. Affidavit of Richard Green in support of defendant's opposition to Commonwealth's motion to exclude certain testimony of defense witness Richard Green. I, Richard Green, under oath, do depose and state as follows. This is the way we do it in New York. This is great. It's great to see some New York writing. So we don't say under the pains and penalties of perjury in New York, although he may have to say that for Massachusetts, but under oath, do depose and state as follows. Finally, some lingo that I recognize. Oh. All right, come on. You know I like a continuous scroll and a red pen. Here we go. The following facts and information are based on my own personal knowledge, and I could testify competently about them if called upon as an expert witness to do so. I declare that the following is true and correct to the best of my knowledge, and that I have no personal interest in the outcome of this case. I am president and owner of United States Forensics, LLC, hereinafter USF, a digital investigation and a data forensics company that provides services to clients nationwide. Copy of my curriculum vitae is attached here too as Exhibit A. For those of you who don't know, a curriculum vitae is a fancy word for resume. I have more than 25 years of experience as a computer forensics technician and 18 years of experience conducting electronic data analyses and investigations, including analyzing computer data, cell phone data, cloud data, digital cameras, and DVR data, metadata media, and audio and video analysis and enhancement technology. I have conducted thousands of investigations, involving computer and cell phone forensics, data recovery, computer networking and maintenance, and audio and video enhancement. My services have been retained by numerous attorneys across the country in both civil and criminal cases, offices of the public defender, and law enforcement agencies. I have been qualified as an expert in digital forensics in numerous state and federal courts throughout the nation, including California, Florida, Michigan, Kentucky, North Carolina, Ohio, and Massachusetts. I obtained my associate's degree in digital forensics and computer investigations from St. Petersburg College. I'm a certified computer examiner with the International Association of Computer Forensic Examiners, which is a globally recognized certification in the field of computer forensics and requires continuing education and recertification every 3 years. I also hold the following certifications: a computer-related crimes investigator certification from St. Petersburg College, a cybersecurity certification from St. Petersburg College, and a computer forensics first responder certification. Thank you, Cheryl, for putting up the Amazon link. It's a fun and free way to support the channel. If you shop through my Amazon link, whether you buy the stuff I recommend or not, it helps the channel. You can just actually do your regular Amazon shopping through my link and just buy the stuff you normally buy. Costs you no more. And, it helps the channel. So thank you. Thank you. Thank you, Cheryl, for putting that up there. And thank you to those of you who have been using my Amazon link to shop. Oh, thank you, good citizen, for thanking me for just being me. That's so nice. And Edward, thanks for the 5. Hank said he intended to Rule 14 exclude ARCA in future, but has not filed for it yet. Correct. He was waiting on the federal response to his discovery request. I don't know what he requested from the feds. Did we go over that? Thank you, Edward. He said he was going to make that motion in the future because he did not think, what he said was he didn't think that the defense was going to be able to respond to his Rule 14 request, that the defense wasn't. So I'm not sure about if he's requested anything from the feds. That I don't know. All right, moving on. I am also personally licensed to operate a private investigation agency in both Florida and Michigan. Which is a requirement to operate a digital forensics company in both states. I am presently a member of the following professional associations in the field of digital forensics: ISFCE, which is the International Society of Computer Forensics Examiners; IACIS, the International Association of Computer Investigative Specialists; NACDL, the National Association of Criminal Defense Lawyers. I was the keynote speaker on electronic data forensics at the 2008 Midwinter Conference hosted by National Association of Legal Investigators. Throughout my career, I've kept current with developments in electronic data analysis, including computer forensics and investigative training from St. Petersburg College and first responders. A lot of this is repetitive from what we already read, so I'm gonna scroll through this quickly in case you want to come back and read it yourself later or screenshot it. So you know all of his trainings and things that he has done. All of these trainings in 2024. I think they said there's something like 67 of them. It says this list is not inclusive of many of the web training sources that I follow on a continual basis. Here is a whole nother page. All of the other trainings that this expert witness has done. Even more. And more. And more. Entire page 4. Initial data production. USF was initially provided with a Celebrite UFED report prepared by Trooper Nicholas Garino with the Massachusetts State Police, which was labeled as a full file system extraction of an iPhone 11 belonging to Jennifer McCabe. In the initial report prepared by Trooper Garino, the 2:27 a.m. search for Haas Long to Die in Cold did not appear. Recognizing that this report was not the best evidence, we've had a lot of that, not the best evidence, including inverted videos and copies of screenshots and other videos. I personally requested the image file for the phone in question, which I had reason to believe was produced using the Gray Key product based on the naming convention contained within the Celebrite report. I subsequently received a USB drive containing a forensic image of the iPhone 11, described as J. McCabe belonging to Jennifer McCabe, which was forensically imaged by the Massachusetts State Police using a tool known as Gray Key. The USB drive containing the forensic image was sent to USF by Assistant ADA Lally with the Norfolk County District Attorney's Office by way of Trooper Garino with the MSP. Upon receipt, the USB containing the image of Jennifer McCabe's cell phone was assigned an internal evidence number with USF, and that is his evidence number. Notably, the USB drive containing the forensic image of Jennifer McCabe's cell phone failed to include the associated documentation containing hash value. Wow, so the hash values weren't even turned over to him. Anybody surprised? Which is a well-known mechanism used to validate the data and ensure that it has not changed or otherwise been manipulated. After personally insisting that the Massachusetts State Police provide the hash value associated with this data, USF was eventually provided with a PDF containing the purported hash value, and the value listed within that PDF matched the Gray Key image file of the cell phone in question. After obtaining the full file system extraction of the data contained on Jennifer McCabe's iPhone 11, the data images were processed and reviewed with the Celebrite Physical Analyzer and Axiom. Opinion number 1, it is my opinion, based on a reasonable degree of scientific certainty, that the user of Jennifer McCabe's cell phone searched Haas Long to Die in Cold at or before 2:27:40 a.m. I have questions about this PDF. I'm sure that Olivia, we'll cover that later, because I am not a forensics expert, nor have I ever claimed to be. In my professional experience, an analysis of a device's internet search history often gives valuable clues as to the user's intent or knowledge surrounding an incident. I conducted a review of the search history information obtained from Jennifer McCabe's iPhone 11 and observed the following significant artifact from the morning in question as reported by Celebrite Physical Analyzer and Axiom Forensics, which were the most recent versions of the respective tools at the time I conducted my initial analysis. Search term, Haas Long to Die in Cold, last viewed date and time 1:29:22, 2:27:40 a.m. Here's the URL. Here is the source. State deleted, type WAL file. Celebrite processing. In Celebrite Physical Analyzer, the 2:27:40 a.m. Haas Long to Die in Cold search not only showed up in the web history, but Celebrite further refined the results and included it in the searched items artifact section. It was marked as a deleted record with an adjusted last viewed timestamp of January 29th, 2022 at 2:27:40 a.m. Noting the inconsistencies in Cellebrite's reporting between the UFED report generated by that version and Cellebrite's physical analyzer, I contacted Cellebrite's technical support to inquire if they could provide additional information about this artifact. Cellebrite's technical support staff indicated that they believed the artifact was reliable and that no issues had been brought to their attention. On April 22nd, 2024, the Commonwealth's expert, Ian Whiffen, emailed me stating, the last visited time shown in PA will be getting removed from the artifact in the next available version of Physical Analyzer. Okay, hold on. On April 22nd of 2024, wasn't the trial ongoing? And that's when Ian Whiffen is emailing him? Telling him it's going to be getting removed from the artifact in the next available version? After the start of the trial in this case, in late May of 2024, Cellebrite released in Sayet's physical analyzer, V10-2-101-352, which removed the 2:27 a.m. timestamp from its processing of the artifact. Okay, Lauferio, did you just send me a $500 super chat? What? Keep up the good work. Much respect. Are you sure you didn't type that in wrong? Holy crap. Thank you so much for your incredibly generous $500 super chat. Everyone, thank you to Lauferio. Wow. Thank you. I don't know what to say. I'm speechless. I'm really speechless. Shortly after trial, on July 22nd, 2024, Cellebrite released its Cellebrite Physical Analyzer standard, which also removed the 2:27 a.m. timestamp from its processing of the artifact. Notably, Cellebrite is a company that markets itself as providing digital intelligence solutions for law enforcement and is used by over 6,900 public safety agencies in over 100 countries worldwide. Although I am aware that Cellebrite recently changed its analyzer program so that it no longer reports on the timestamp of this particular artifact, I have not misinterpreted the data. 14, Axiom processing. Axiom is an application product offered by Magnet Forensics, which is a competitor of Cellebrite. Hold on one second. Best practices in digital forensics require forensic examiners to view data and artifacts with more than one tool. Therefore, I also process the image of Jennifer McCabe's iPhone using artifacts with more than one tool. Oh, therefore, I also process the image of Jennifer McCabe's iPhone using Axiom version 6.11. Axiom version 6.11 reports the 2:27 a.m. search artifact for Hoslong to Dying Cold with a last viewed time of 2:27:40 a.m. in the Safari Suspended State Tabs section. Shortly thereafter, I contacted Magnet Forensics technical support to see if additional information could be provided regarding this artifact. I was advised by technical support that the 2:27:40 a.m. timestamp indicates that the search would have occurred sometime at or before the 2:27:40 a.m. time indicated. Since my initial analysis, USF has upgraded to the more advanced Axiom Cyber Physical Analyzer, which was released on December 17th, 2024. This version of Axiom continues to report the above artifact with an even more precise last viewed date and time of 1:29:22 at 2:27:40.465 a.m. in the Safari Suspended State tab marked as deleted. So it is even more accurate now than it was then. More accurate, marked as deleted. Axiom is more accurate, and it was just released a month ago. Take that. Footnote 2, I'd also like to note that Trooper Nicholas Garino's report labeled this specifically mentions that he also used the Axiom product to process the forensic image of Jennifer McCabe's iPhone. I personally tested the earlier version of Axiom, which would have been used in February of 2022, and determined that the 2:27:40 a.m. version of the Haas Long to Die in Cold Search was reported by Axiom as having a last viewed time of 2:27:40 a.m. Axiom has a similar feature to Celebrite with their creation of a portable case. This exculpatory information was never turned over to the defense. What? Oh, Garino, you going down, 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 and it's not even going to be in a blaze of glory. You going down. Garino used it. He didn't report it. He just left it out. Brady? How about Brady Bunch? All right, I got to go pick up my kid at the bus stop real quick. We can either table this and we'll finish it later when I come back with Mark at 7. Why don't we do that? We'll stop now. We're going to come back and read the rest of this later, but I'm going to leave you off with that little bombshell right there. Garino used Axiom. And that exculpatory information was never turned over to the defense. And that is why, my friends, that is why the motion for dismissal based on egregious prosecutorial misconduct, or whatever they're going to be calling it, Brady violations, not turning over exculpatory information, is a problem for this is, I mean, any honorable DA would come out and say, you know what, wave the white flag, charges dismissed, go home, everybody go home, like they did in New Mexico. Ipsy Dixit, no. Karina Reichman, no, don't know who that is. Thank you, Edward. He's trying to play a switcheroo, asking defense to supply stuff that only the feds have original contract terms of federal investigation, etc. Yes. Fur Baby Mama became a new member. Thank you. Again, Lafurio, you're the greatest. Thank you for the 500. I'm going to read the rest of this. I'm going to digest it more. We're going to talk about it later with Mark. You're not going to want to miss it, my friends. You're not going to want to miss it. So when I hit end on this, it's going to teleport you over to the 7 p.m. stream. Save your questions for later. There's a lot more to get to. Nothing like leaving you on a cliffhanger, my friends. Thank you so much for joining. Mods, thanks for keeping it classy. I'm going to see you a little bit later. What a cliffhanger bombshell. OMG. You ain't seen nothing yet. Peace, my friends. I'm going to see you real soon. Stay cool, stay kind, stay classy. You can do it. I know you can do it.